Hello and welcome. Thank you so much for joining us this week on the Employment Law Show. My name is John Scholes. With me as well, employment lawyer Lior Samfiru. Want to reach out to Lior anytime? Do so by phone call 1-855-821-5900. Match it up with the email, which is help@employmentlawyer.ca, and a website which we're going to get to a little later on. It's the only one you really should use. That's why Lior put it together years ago, because there's so much bad and misinformation out there as well. Between Google and blogs and everything else, do not use them. Go right to the source, pocketemploymentlawyer.ca. We'll tell you why in greater detail as the show goes on. There's always a main topic as well. This week it is sick leave and job security, the truth about your rights. We'll get to that in the second segment. Phone calls, emails, questions. It's always chock full of good stuff. And the week that was, of course, from Lior, which is going to happen right about now, pal. What do you got cooking this week?
Right now, absolutely. We want to demystify this topic on the show like we do every week. Every single week, people call me after they saw the show and they say, man, I learned something. I now know what to do if I'm facing a workplace issue. That's why we're here. We're going to keep being here. We're going to keep fighting the good fight and giving out the good word so that you know what your rights are. You have a right to know those rights. You have a right to know how to react and respond if something bad is happening in the workplace, if your boss is mistreating you, if your job is being changed, if you're being threatened into doing something, you're being forced to resign or forced to reduce your hours. In all those cases and so much more, the law comes in and says, not so fast. That may be illegal. There's options, there's rights, and there's penalties for an employer that breaks the law. And those are significant. Those are severe. We have very good employment laws here. I want everyone to know those rights. The internet could be a scary, confusing, and frankly, misleading place when you're trying to understand your workplace rights. AI, man, it's a big thing. A lot of people go to ChatGPT, ask about rights, and they contact me, and it's wrong, and it's confusing, and it's all garbled up. Do the right thing. If you want to understand your legal rights, this show, call me. We'll give you that contact information throughout the show so that you can reach out. But please, those are the best options to understand your rights. You don't want to mess with that. You want to make sure that your rights are properly pursued. Don't leave that to chance. And let's give you an example, a case of the day, kind of where I'd like to start off always. I spoke with a gentleman who was let go and was expecting a big bonus right before he was let go. Well, his employer said, hey, we're letting you go before the end of the fiscal. You would have had to be here at the end of the fiscal year to get this bonus. And by the way, that bonus was significant, about $20,000. But because you're not going to be here, we don't have to pay you this bonus. That's kind of our policy. That's our practice. If someone's not here on the day the fiscal ends, they don't get the bonus. And he called me and he wanted to understand, is that okay? And do they not have to pay bonus? Did he kind of lose out because the employer decided to let him go before the end of the fiscal year? No. It's not how it works, and it's not something the company can get away with. Your severance has to include all components of compensation, and it has to include everything you would have received if you'd stayed on working. So in this case, if he had stayed on beyond the fiscal, he would have gotten the bonus. That means it has to be included as part of his severance. So not only, get this, not only does he get his $20,000 bonus, his severance is calculated based on the bonus as well. So he gets the bonus for last year and on a go-forward basis. So twice, really. So this is such an important thing. Because of that, for him, that means that his severance automatically would be better off by about $30,000. I want everyone to remember that certainly when it comes to bonuses, the company cannot generally pick a convenient termination date so that they can avoid paying you money that they owe you. Maybe it's a bonus, maybe it's a big commission check. They can't do that. Imagine if the law allowed a company to do that. Well, every company would then say, hey, we have to pay this guy a bunch of money tomorrow. Let's let him go today and save up that money. No, doesn't work that way. You still have to pay it. And by the way, an employer that does that and plays those games may have to pay additional damages because they're not acting in good faith. The other thing I want you to know and remember is that your severance has to include all components of your compensation. Salary, bonus, like in this example, commission, benefits, pension plan contributions, gym membership, car allowance. If you want to know if something needs to be included, you ask yourself, would I have received it if I had continued working? And if the answer is yes, then it has to be part of your severance as well. Company's not going to forget about your base salary, but there may be many other components to your compensation. Those have to be included as well. So it's not just about the number of months you're offered, it's about also what's included in it.
So he didn't get the 20K. Did he at least get enrolled in the Jelly of the Month Club? Did he get that one?
Not even that, although that is the gift that keeps on giving
The whole
year-round.
year.
No,
That's right.
no,
You know, it's interesting because not always, but sometimes bonuses are tied in with salespeople, and then there's commissions involved as well. And we've often heard the same thing with commissions. Well, you know, we let you go before that commission payment came in from whatever, you know, client, therefore you don't get it. That doesn't hold water really anyway, does it?
If you're on a commission and you've done whatever you needed to do in order to earn that commission, your part of the transaction is complete. You finished it. Well, then you have to get paid that severance even if you're not going to be there when the money actually comes in. If you've done your job, you have to get paid severance. You've earned that money. And it's very, very difficult for an employer to try to avoid paying an employee money that they have earned. Not enough to say you're not here, not even enough to have some sort of a policy that says that. It's going to be very tough. In most cases, they have to pay it.
Our radio show has been going on for such a long time. It's great, full of information weekly. It happens nightly, as a matter of fact. Employmentlawyer.ca to find a station that carries it in your market. We'd love to hear from you as well. Do that by way of phone call. We play back a lot of them on the show because they're informative and educational. For this show, first phone call of the show is coming up right now. Listen up.
My wife worked for a company 24 years. They decided to close down. She was terminated, and they offered her $1,000 severance. And severance pay is payment for basically the years you worked for a company.
How much notice did you get approximately?
Too much.
What kind of a job was she doing, and how old is your wife?
59. She's been doing sort of accounting, accounts receivable, payables.
Seems a little light, $1,000.
Dude, we can't make this stuff up.
Seriously.
You know, $1,000. Here's your $1,000 after 24 years of service. So, of course, that's illegal. But there's something else I want to talk about here, and that is the fact that the company is shutting down. Let's assume that's correct here. Well, the fact that the company is shutting down does not relieve the company from the obligation to pay severance. Shutting down, going out of business, retiring, none of that says you don't have to pay your full severance. Now, if the company is actually in bankruptcy proceedings, very different. They may not be able to or have the ability to pay that severance. But anything short of that, shutting down, closing down, retiring, business is slow, you have to pay that full amount. And for this person, that $1,000, I'm sorry, is a joke in comparison to what they're actually owed. So I want to take you for the first time on the show today to the severance calculator so that you can see how much severance is owed and how to properly assess it. So we're going to go to pocketemploymentlawyer.ca. We're going to click on our severance calculator there. You can do that at home for free as well. And let's see what this gives us for this person after their 24 years of service. So in an accounting role, 59 years of age, 24 years of service. Hey, company says, here's your $1,000, go away. Nonsense. 24 months. You see right at the bottom, that's how much severance is owed. 2 years of pay, not $1,000. That's a wrongful dismissal if I've ever seen one. Please, common situation, unfortunately, as extreme as it is. So it doesn't matter how much you've been offered. Chances are you're owed more. So what do? Again, pocketemploymentlawyer.ca.
That is phone call number 1 for the show. We get 3, don't you know? Number 2 is coming up right now. Listen up.
Recently started a new job 2 weeks in. I definitely, having trouble adjusting to my new job. Manager came up to me and asked me to contemplate whether you want to work here anymore. I've said, well, if you want to let me go, it's up to you. If that's the case, please talk to the hiring manager or whoever from there instead of, to me it sounds like he wants me to resign.
Well, of course they want him to resign because if he resigns, they don't have to pay severance. They're relieved of their severance obligation. So this person is actually handling this appropriately. They're saying, no, I'm not leaving. If you want to let me go, I guess I can't stop you. And the reason why that's important is, even though he may have just started the job, if he's let go, he's still going to be owed severance. Now, he's maybe struggling. The job may not be going fantastic, but that does not relieve the company from the obligation to pay full severance. Now, if he was a terrible employee, he was not showing up to work, he was making massive mistakes and taking off for hours at a time, maybe then the company can let him go without severance. But if it's one of those things, maybe it's not a great fit. Still, severance has to be paid. And the last thing you have to remember is you may think, okay, we get it, severance, but he's been there a short period of time. What is he going to get, a week's pay? No. Even though he's only been there for a short period of time, the amount of severance is likely still going to be measured in months. not days, not even weeks, but in months. So yes, just because he's a short service employee does not relieve the company of severance. He did the right thing. Told the company, hey, I'm working. I'm going to continue doing my best and hope to get past this difficult patch. If you want me gone, you have to let me go. Don't give the company the gift of saving them severance by resigning. If you don't want to resign and the company wants you gone, they should let you go so that you can get your severance.
You know, this employee sounds very conscientious. He wants to improve. He wants to do a better job. Therefore, I'm not leaving. Would a nicer, more proper employer say, you know what? Perhaps we should give you some training. Maybe put you on probation even, but we'll try to help you out to improve your situation rather than just booting him and paying him severance?
Listen, if you're asking me what should a good, responsible employer should do, that's exactly what they should do. Help support this employee, give them the training, the help, so that they can become productive, so that they can get past this difficult patch and hopefully be there with you for a long period of time. Unfortunately, the law can't make someone a good employer. So if an employer chooses not to do that, the law is not going to punish the employer for doing that. But the law does say that if the employer instead chooses to let the employee go, severance has to be paid, again, measured in months. So there's that trade-off. But a good employer is going to help and support that employee.
As we say, there's 3 phone calls. The third one comes after the break and follows up with our main topic as well, which we'll get to momentarily. Stick with us as we continue more of the Employment Law Show. We're coming right back. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back to the Employment Law Show. Thanks for sticking around through the break. We appreciate that. Reach out anytime to Lior and his team by phone and email as well. 1-855-821-5900. Toll free, of course. And the email is help@employmentlawyer.ca for all other matters. And to educate yourself on your own time, you know that website now, pocketemploymentlawyer.ca. We'll get to our main topic in just a moment here, but we have one more phone call to get through, so we'll answer those questions as we get to that right now. Listen up.
My wife is working, she's been in the company for about 10 to 15 years. She works Monday to Friday. However, they're starting to change her days of work. They've told her that now they're going to need coverage on the weekends and that they're going to have to rotate and start working Saturdays. I don't know about Sundays. They're going to be forcing them to work Saturdays now. And I didn't know if that was enough to constitute a dismissal.
Boo, weekends, boo.
Yeah. Listen, if you're someone that doesn't work weekends, you kind of work Monday to Friday, now to have to work weekends is a massive change. Anyone that's ever had to do that is going to tell you. It's a big change. It's a change in lifestyle. It may impact your parental obligations, family obligations. It's a huge deal. And because it's such a huge deal, the law understands that. And the law says, no, your employer can't just do that. If you're working weekdays and your employer wants to work weekends, it's something that they're not allowed to do, and you can say no, and you can't be punished for it because it's beyond the scope of what your employer can do. And that could easily be a constructive dismissal. But what I want you to understand is this. Even though it's not legal, can't do that. Let's be very clear. If you say no, could your employer let you go? Yes, as long as severance is paid. Remember, that's because your employer can let you go for most reasons as long as severance is paid. Just like they can let you go because you have a car that's too blue, they can let you go if you don't come into the office on weekends. Again, not nice. Legally, they can do that. What they cannot do, John, is consider you to have resigned, consider you that there's grounds to let you go for cause without severance. Absolutely not. That's beyond the scope of what an employer can do.
You know, I always ask you, or quite often on the radio show and the TV show as well in this situation, if you're thinking, okay, well, you know, the kids have left the house, I got a bit of free time, I guess I could work weekends, I don't really want to, but I like the company. Can I try it but not commit 100% to it?
You can, and it's not even a bad idea in some situations, but you have to do that by telling your employer in writing. I say telling, but I mean writing to your employer and telling them that I'm only going to try this for a period of time. I don't know how that's going to work. I don't know if I'm going to be okay with that. You've asked me to do it, so I'm going to try to do it. So I'm going to do this for the next month, 2 months, and after that, I'm going to let you know how I feel. As long as you tell your employer that that's what you're doing. You haven't accepted this forever from now on. You're trying this on a temporary basis. Once that period of time ends, you can decide still, are you okay with that? Are you not? You would still be able to consider that a constructive dismissal as long as you tell your employer that you're only accepting this on a temporary basis.
Good stuff. Let's get into our main topic again this week. It is sick leave and job security, the truth about your rights. Number one, Lior, can your employer fire you while you're on that sick leave?
Generally speaking, no. You cannot be let go because you have a medical condition, because you have a disability, because you're going to be off sick. Now, an employer may say, man, it's creating logistical problems for us. We don't know if you're going to be here, if you're going to be coming back, if you're going to need some support. So it's just easier to let you go. No, can't do that. Illegal. You have the right to be off as long as you need to, so long as you have that doctor's note, and you cannot be let go because of it. Now, could you be let go in a situation where it happens that the whole department is being shut down, everyone is being let go, and you happen to be on a medical leave? Yes, that could happen. But if the termination has anything to do with the fact that you're sick, the fact you're on a medical leave, that could be a human rights violation. It could be an employment standards violation, wrongful dismissal, you name it, illegal, shouldn't do that.
So what happens if your employer refuses to accept that medically backed leave?
Well, it's very simple. It's not up to them. They don't get to refuse. They don't get to do anything other than follow what your doctor says. When you need to go on a medical leave, you're not asking for permission. You're letting your employer know. As long as you have that doctor's note, that's all you're doing. Hey, employer, here's my doctor's note that tells you that I'm going to be off for medical reasons effective Monday. That's it. Your employer doesn't get to question that. They don't get to say, well, I'll think about it and I'll let you know. No, it's not a discussion, it's not a consultation, it's not a permission-asking situation. You're telling your employer. Your doctor decides that. If it's a medically necessary leave of absence as stipulated by your doctor, you can be off and your employer can't do anything. And if your employer tries to give you a hard time, refuse, threaten you, you got to give me a call. I'll get him off your back.
Is there a length of time that leave can last before your job's kind of at risk at that point?
Well, generally, no. You can be off as long as you need to, so long as you have your doctor's support. And in some cases, the doctor may not even know, initially at least, how long you're going to be off work. When you have this medical condition, you're going to be off indefinitely, and your doctor is going to assess down the road. Some cases, that may be days, weeks, months, even years potentially, and you can still be off and your employer can't do anything to you. Now, at some point, if your leave is now in the years and there's no likelihood of ever coming back, your employer may be able to end employment on the basis of what we call frustration of contract. Very difficult to do, and usually we don't even have that discussion until you've been off for years. So yeah, you can be off as long as you need to.
Now, if you're off for a lengthy time or not, if you're fired, are you owed just severance, or is there severance owed, or what else?
So first of all, if you're let go on a medical leave and if the reason you're let go has anything to do with that medical leave, as I said, that could be a human rights violation, that could be human rights damages. It could be an employment standards violation, that could be damages flowing from that. And of course, yes, you get severance as well. But here's the thing. Because you're on a medical leave, presumably that means you're not healthy. You can't just go and find another job tomorrow because you're still dealing with a medical condition. The fact that that's the case means you're going to be owed even more severance than you would have gotten if you were healthy. Anything that makes any factor that makes it more difficult for you to find another job can increase your severance, like having a medical condition. So yes, being let go on a medical leave can be very costly for the employer. Human rights damages, reprisal damages, extra severance. Man, you better call me if that happens to you so that we can make sure you get what you're owed.
And that'll wrap the main topic for this week. We got to take one more small break. We'll come back with more of your emails and questions, and employment rights rapid fires coming up at the end of the show as well. So stick around for that. More Employment Law Show is coming up.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
And we are back. Thank you so much for sticking around to the Employment Law Show. Again, reach out to Lior and his team anytime. Any questions, do so by phone and email 1-855-821-5900, help@employmentlawyer.ca. Only website you need, pocketemploymentlawyer.ca as well. As far as that's concerned, there's other opportunities and avenues to ask questions as well that Lior's team gets to, and some may appear on the show as well. For instance, terminationquestions.com. That's free and anonymous. Terminationquestions.com. For this week, from it, I'll get to the question. Lior says, I was let go with cause after 6 years. I'm a flat rate mechanic that gets paid $30 per hour. When I was let go, I was told it was due to 3 work orders that were not provided for review, saying that I made mistakes and it cost the dealership. When I questioned them about the orders, no further information was provided to me. What can I do?
By the way, car dealerships, I'm sorry. I have friends that work at car dealerships, but it's the Wild West when it comes to employment law. It really does. It is what it is. I've been acting for them and against them for years and years, so I can say that. But let's break this down here specifically. The fact that let's look at it from the company's best case scenario. He may have made some mistakes on some orders or some jobs. Let's take that as a fact. The fact that he did that does not mean he can be let go for cause. Does not mean he can be let go without severance. The reason for that is the only time someone can be let go for cause without severance is if they've done something that's so over the top, so bad, that there's no possibility of employing them. And if you've been there for a bunch of years and you made some mistakes, it's just not going to be enough. It's not. People make mistakes. The company should work with you, give you some help, support, maybe in some cases give you warnings and say, hey, this has got to improve. What they can't do is say, everything is great. Next month, now we're letting you go for cause. Does not work that way. And certainly this company didn't try to do that, didn't provide him help, didn't provide him warnings, doesn't appear, didn't even give him all the particulars so that he can respond to these potential mistakes that he made. So this is a wrongful dismissal, and I want you to remember it's very, very difficult to terminate for cause without severance. So we've established now that this person is owed severance. We know that. Last thing we got to do now is figure out how much severance does he get. We're going to go for that to pocketemploymentlawyer.ca, and let's find out what the right severance amount is for him. So he's a mechanic, been there for 6 years. Company is saying you don't get any severance because you made mistakes. As I've said, can't do that. He's owed right around 8 months of severance. He's been wrongfully dismissed. He should get paid that. I will help him get that. You at home, whether you let go with or without cause, or maybe you haven't been let go at all, but you want to find out how much severance is owed to you if it does happen, pocketemploymentlawyer.ca. Just click on the severance calculator.
Thank you so much for that question. I want to remind you as well, there's live streaming going on with Lior and his crew. They answer your questions live on air. You'll want to get that on Facebook, YouTube, and LinkedIn. To join in any of those, at stlawyers.ca, at stlawyers.ca. The one for this week, Lior, comes in like this, says, when I joined my current workplace, I signed an agreement which stated my role was fully remote. You know what's coming here, right? Fast forward a few years, they want me to come back into the office 4 days per week. Is this not a breach of my contract?
That's exactly what it is. It's literally a breach of the contract. You have an agreement, a contract that says, I'm going to work remote. Now they're saying, forget that. We're going to change that. You're going to come into the office. Can't do that. By the way, what I'm about to say is going to apply whether you signed a contract that says that, or maybe you didn't. You just have been working remote because that's just the way it is, and now the company wants to change it. An employer cannot do that. That is a significant change to the terms of employment. If you were hired to work remote, or maybe you weren't, but you have been working remote, now they want you to come into the office. That is a big change. They're not allowed to do that. You can refuse. You can't be punished. You can't be fired for cause. You can't be considered to have resigned. You're able to say to your employer, no, that's not the deal. I've been working remote for a while, or I was hired to work remote. I now am going to continue working remote. The company doesn't get to do that. No more than if you were working in office, you can say, I've decided from now on I'm working remote. You couldn't do that. Well, the same thing applies to your employer. They can't change it either. So you have options, you have rights, and if your employer is still pushing you, let's have that conversation.
You know, it's interesting because this one over the last few weeks, as you know, is kind of super timely with people being asked to go back to the. It's happened in my house as well. Is there a time when that's allowed, government workers, or if it's been happened previous, maybe it's in a contract that you signed 7 years ago? I mean, when can they maybe get away with it?
So if you sign anything once you became a remote worker that says, hey, we as the employer have the ability at any time to bring you back into the office, then they can. That was a condition of you working remotely. If you over the past number of years, sometimes you work remotely, other times you were called in and you went, and so we've established that history of in and out of the office, then that is legal. So in those cases, the company may be able to tell you, you have to come in. But if you haven't signed something that gives them the right to call you into the office, and you have been working remote almost exclusively for an extended period of time, then no, they cannot do that. Working remote is a term of your employment. Again, we're talking non-union employees as usual here. It's a term of employment. They can't change that, and they can't consider you to have resigned or fire you for cause if all you're doing is trying to stick to the agreement that you have in place with your employer.
You know, a few years working remotely could mean that your lifestyle has changed. Maybe there's kids involved now, parental duties. Does that strengthen your position, saying, I'm not coming back?
Absolutely. Absolutely. And I'll take it a step further. A lot of people, well, I've been working remote, so I don't have to be close to the office, so I'm going to move. I've always wanted to, live in this particular area that's far away from the office.
Like COVID.
It happened a lot during COVID. So if you've moved now they want you to pretend like that never happened and go back to the office. Of course they can't do that. And yeah, that strengthens your argument. But even without that, even if you still live the same place, fairly close to the office, it's still a big deal to make you an in-office employee instead of a remote employee, not something your employer is allowed to do.
And we wrap up each weekly show with a little segment we call Employment Rights Rapid Fire. He's the one under fire. I get the questions. We'll do that right now. All right, employment rights rapid fire. This part I like the best because I just ask them. I don't have to answer them. Lior, number one, can an employee look for another job while still employed? Very common.
Very common. Absolutely. That's not considered any form of workplace misconduct. You can look for another job. Your employer can't punish you if they find out. Probably not a good idea to make them aware of it. But if they find out, not a big deal. You haven't done anything wrong.
Employment rapid fire number two. Are employers able to terminate employees while on a parental leave?
No. You're on what we call a job protected leave, meaning you cannot be let go because you're on a leave, about to take a leave, or thinking about a leave. That could be a violation of several statutes and a wrongful dismissal, illegal.
Number three, are pay deductions a permissible form of discipline?
Man, no, not at all. Your pay is sacred. What you earned has to be paid to you, and the company can't deduct that without your written consent. So no, an employer should never deduct anything from your pay. They should pay you everything you've earned, regardless of any other circumstance.
Rapid fire question number four is this: is an employer able to monitor employees in the workplace?
Yes. The answer is yes. Generally, as long as you're within a kind of publicly accessible area, certainly they can't monitor you in the bathroom, in the change room, where you would expect privacy. But in other areas of the workplace, they can monitor you. They can record even as long as they tell you that they're doing that. And there's not much that you can do in those circumstances.
Finally, can an employer lie about the reason for termination?
Believe it or not, they can. An employer does not have to tell you why they're letting you go. They don't have to be honest about the reason. They should,
right,
but they don't have to as long as they pay severance.
And that is it. We are done. Reach out to Lior anytime and his crew now. 1-855-821-5900. Help at employmentlawyer.ca. And we'll see you next time on the Employment Law Show. Thanks for joining us.